All right, well, we might make a start. I think everybody is here, so thank you everybody for coming today. My name is Ruth. I'm a law graduate here at Gladwin Legal, and I am very excited to be sharing with you today on trademarks and copyright. What's the difference? So aspects of intellectual property law might touch your life and your business. And so today we're going to take a little bit of a broad overview into these two areas. All right, so intellectual property, what is it? Trademarks and copyright are two different types of intellectual property. And intellectual property refers to property or assets created by your mind. There's a number of different kinds of intellectual property, and they're protected in different ways, which is why it's so important to understand the difference. So let's talk about the difference between the different types of intellectual property. So trademarks protect your brand and can be one of the most valuable assets of your business. You'll realize that some of the most successful businesses are those which have really strong branding and trademarks, such as Nike or Apple. You might immediately think of Nike when you see the swoosh, the little tick symbol, or Apple, the little Apple logo, just things that are really recognizable. So to claim legal ownership of your trademark and enforce your rights in it against other businesses, you'll actually need to formally register your trademark. Copyright, on the other hand, protects the expression of ideas, but not the ideas themselves. For example, you might have an idea to create like a new cinematic universe, like Marvel or something. But unless you actually put pen to paper and write the script or film the movie, that idea isn't protected. It's only the expression of it as either a script or a film. So unlike trademarks, you don't need to register copyright to receive protection, but we'll talk a little bit more about that later. So apart from trademarks and copyright, there's several other types of intellectual property. This includes patents, which protect useful inventions, methods, or processes. For example, the iPhone is patented, or the formula for the Pfizer COVID-19 vaccine. And then there's other types of IP like designs, which protect the visual look of the product. So for example, you might think of like a Rolly watch or like Nike Airs, things like that, that protect the visual appearance. And then there's also confidential information or trade secrets. So if you think about KFC and like the flavoring for the chicken, how it's like really good, that is sort of like a trade secret, you know? So yeah, when we talk about intellectual property, we talk about things that require some sort of creativity or innovation. So from a broader perspective, having laws and systems in place which protect intellectual property, they help move society forward with innovation, creativity, and commercialization. So when creators have confidence that their ideas or their brand is protected properly, or that they can commercialize their invention if they create something really cool, they're incentivized and encouraged to keep creating things. And then on the other side of things, society benefits because the public can benefit from, you know, new inventions, technology, and new books and movies and art and music. So yeah, it's a really helpful way of moving society forward. And then with trademarks specifically, businesses can benefit as they can trade without their competitors trying to copy their brand or benefiting off the goodwill that they have. So let's talk a little bit about trademarks and branding. All right. So trademarks are parts of your brand which help customers to distinguish the goods and services of your business from that of others. So while you might think of like a logo or a name as the first thing that pops into your head when you think about a trademark, you can actually trademark a range of other things, including shapes, sounds, movements, scents or like colors. And when we talk about scents, we talk about like smells. So some examples include like the Coke bottle, like that actual shape is trademarked, or like Toblerone packages, the chocolates, that's trademarked. With colors, you can have like the teal color of like Tiffany and Co. Boxes, so that's trademarked. And then sounds, you might think of like Macca's, like da 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 da, like that I'm loving it jingle. Things like movement, so maybe like the Toyota Jump in their advertisements. And then with scents, like things like the smell of Play-Doh is actually trademarked. So that's sort of like musky, like vanilla sort of smell. So it's really interesting that you can trademark not just like your logo or a name, but there's actually a range of things you can trademark. So when you register a trademark, you register and protect it in relation to specific classes of goods and services. So in IP Australia, which looks after all the IP and trademarking and things like that, there's 40 classes of goods and services. And a key part of the whole registration process is actually deciding what classes you want to register your trademark in. So for example, if your business sells t-shirts, you want to register it in class 25 because you would receive protection in case another business wants to come in and register a similar trademark to yours for t-shirts. And it's really important to register your mark in relation to the goods and services you are actually trading in, because it can be difficult and really time consuming later on to try and expand your goods and services after your mark has been registered. So let's talk about what is the benefit of registering a trademark. Firstly, registering your trademark gives you a business asset. So earlier on, we talked about like Nike and Apple and like Macca's and like these things that have these companies that have built a huge brand and reputation over their trademark. So if you're a small business or a startup and you're building your brand and you're marketing your business, as your reputation increases, so does the value of your brand. So that's a really great thing about registering your trademark. It also gives you exclusive rights to be able to use your trademark in Australia and then enforce it against competitors or copycats. And then it also gives you the ability to sell your trademark or license it for others to use. So all these things are really cool things that you get when you register your trademark. So let's talk a bit about branding now, right? So if you're starting a business, picking a brand or a business name will be one of the first decisions you'll need to make. So if you're looking to trademark your brand name, which you should, you'll need to be aware of what kinds of things are more or less likely for you to obtain trademark registration, right? Because if you apply for it, it doesn't necessarily mean IP Australia will give it to you, right? So there's certain things that can't be trademarked. A common pitfall with businesses is where they have chosen a brand name that they think is really great, only to find out that later on that it's not actually capable of receiving trademark registration, or it's very likely to get rejected. And therefore they have to consider, rebranding, changing their whole like marketing strategy. So that's a really unfortunate thing that happens a lot. And yeah, rebranding can be really costly and time consuming. So what can't you trademark, all right? Things that are descriptive. And I'll explain this a bit more, but pretty much you can't trademark words, or it's very difficult to obtain registration for words that directly describe a good or service, because then one business would have a monopoly over terms that everyone should be able to use. So for example, if I had a company that sold citrus fruits and I named it Juicy Orange Company, all right, this is really likely to get rejected because juicy is like a common descriptive word for oranges. And people should be allowed to use the word juicy oranges without infringing on somebody else's intellectual property rights. So in saying that though, it's different if you want to use a word that's descriptive, but not of the goods and services you want to register your trademark in, right? And so if we think about things like Dove soap, which is popular here, it's not registered in relation to like birds or animals, and instead it's to do with like soap and hygiene products. So that's okay, even though it's descriptive. Or as we talked about earlier, like apple, right? If I wanted to trademark the word apple for, fruits, a fruit store, like that is probably very likely to be rejected. But because it's registered in relation to like technological services and goods, it's okay. So similarly, geographical terms, so names of locations, are really difficult to register because it's likely that other businesses will need to use that to describe the origin of their goods and services. So for example, if I had a floral business and I wanted to name it, Melbourne Florist, it's unlikely to be accepted for registration because there's many other florists in the Melbourne area that would likely need to use that term to describe, the location of their business. So trademark registration gives you protection over your mark for 10 years, after which you'll need to renew it to hold on to your exclusive rights. So let's revise some common mistakes with trademarking. So firstly, choosing a brand that's descriptive, which we've just talked about. Other things that are common mistakes are assuming that registering a business name gives you automatic or exclusive rights to use it. So if you're a business, you might have already registered your business name and you have an ABN, and you have your Australian business number, and you use it for your business. However, this doesn't mean that you have exclusive rights to that name, and it's important to still register your trademark on top of that if you want to protect it from copycats and competitors. Similarly, if you have registered a domain name for your website, for example, if I had, lawwithruth.com or something, unless you actually register a trademark, other people can still copy that domain name. So it doesn't give you automatic protection. All right, let's move on to talking about copyright. So copyright. A key part of copyright is that it protects the expression of ideas, but not the ideas of in themselves. So we talked about it a little bit at the start, but you can think of expression of ideas as things like, books, music, art, movies, photos, things like that. And copyright isn't just, the right to copy. It more broadly, it gives you exclusive rights to do something in relation to an original work or subject matter. So it includes the right to copy it or reproduce it, but it also includes other rights. So if you have copyright in something, you can, reproduce it, distribute it, perform it, let's say if it's a song or a musical or something, or display it like a piece of art. Okay? So unlike trademarks, copyright is automatic, and it doesn't require registration to give you that protection. So for example, if I drew a picture of a dog, that drawing is automatically protected by copyright. And yeah, copyright law is really interesting because it's tied really closely to like the creative side of things and originality. The originality that somebody has put into their work or their subject matter. So yeah, sometimes it's really clear that, another business or competitor has infringed copyright. For example, let's say you have photographs of your product, of your goods on your website, and then a competitor has, taken those photographs straight off your website and put it on their own. That is almost like direct, like you can see, okay, this picture is the same as the one that I took for my website, and it's, easier to prove. Other times it can be like a lot more difficult to prove, because you have to show that the person who allegedly took your copied your stuff, copied like a substantial part of it. So for example, recently there was that case with Ed Sheeran in the law. So where he was accused of ripping off Marvin Gaye's song, like Let's Get It On, with his song Thinking Out Loud, right? And if you listen to both, I mean, I won't sing them for you at the moment, but yeah, if you listen to the two songs, they do sound similar, you know, and they have the same sort of yeah, like chord progression, the same sort of vibe. But it's difficult to prove. Like, how do you prove that Ed Sheeran actually, you know, copied Marvin Gaye? Okay, and apparently too difficult to prove because the jury found that Ed Sheeran was not guilty of copyright infringement. So copyright typically lasts for the life of the creator, plus 70 years in Australia. All right, so let's talk now about protecting your IP and how you can do that. All right, so it's really important to conduct intellectual property searches before starting your business. So you don't have to do all this rebranding after doing marketing. So we talked a little bit about it before. Sometimes if businesses, I mean, it can be really exciting with your startup and choosing your brand name and everything. But a lot of the time we see clients that, you know, haven't done the proper searches and then later on run into issues with their trademarks because, yeah, they didn't conduct proper searches. So do your searches before you decide on your branding. The second thing is to be wary of the ownership of your intellectual property. So interestingly enough, your IP isn't necessarily owned by you, as the rights in your IP can be assigned at law. So for example, if you have employees, right, it's really important to have in your employment contracts that state that the intellectual property rights in anything they might create for you while they're employed by you is owned by you as the boss. Because yeah, later down the track might be difficult if that's not set out and they want to take with them their rights in that. So we've also talked about the importance of registering your IP. So not for copyright because that's automatic, but things like trademarks, designs, patents, there's a whole registration process that allows you to protect your IP. And then after that, it's also important to have ongoing protections in place. So things like trademark registration is often just the start. Yes, it helps you protect it, but you also need to be aware of you know, what's happening in the marketplace. So there's things like trademark watching services, which is pretty much a service that allows you to regularly supervise your trademark and any potentially infringing brands entering the market. So that's something to consider as well. All right, so as a summary, let's talk about what's the difference between trademarks and copyright. Okay, so trademarks protect your brand and they require registration for you to use and enforce your exclusive rights in your mark against others. And then not just logos or names, they can also be pictures, sound, shapes, anything that sets the goods and services of your business apart from other businesses. Copyright, on the other hand, protects the original expression of ideas like books, movies, art, and music, but it doesn't protect the idea itself. And copyright is automatic and it gives you exclusive rights to do certain acts with your work, including, you know, copying it, reproducing it, distributing it, performing it, things like that. And yeah, that is the end of my Law Week webinar. Thank you so much for coming, and we'll send a follow-up email with like slides and the recording in case you missed it. If you have any questions, please send me an email. But otherwise, yeah, thank you so much.